So we're on the record in docket 24013337. That is People of the State of Michigan versus Keith Johnson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Johnson, the gentleman who's standing to my right.
And sir, you are Keith Johnson, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I did receive correspondence from Mr. Palmer yesterday that it sounds like Mr. Johnson is seeking retained counsel. So I believe today is going to be a waiver of 21 days.
And is that a fair statement, Mr. Palmer?
That is a fair statement, Your Honor. I will note that it might not be that he's retaining counsel now. There was some confusion because I received a phone call from an attorney named Dennis Path, who advised that he was taking over representation. After speaking with Mr. Johnson, that may not be true. Nonetheless, we still need to work that issue out. And I had already communicated to Ms. Wilson that we would like to waive the 21 days and that she should call off witnesses. So it's certainly not her fault, to be clear. That was based on communications I made. So nonetheless, at this time, we're requesting that we adjourn. I do think that at the very least, it's important that Mr. Johnson and I speak again about the case.
All right, thank you. May I inquire of Mr. Johnson of his waiver of the 21-day rule?
Of course.
Mr. Johnson, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Robert Palmer from the Public Defender's Office, and he would be present to cross-examine any witnesses contesting any charges brought against you. It's my understanding you may be seeking to retain other counsel. That's still in the works. We're uncertain about that. So it's my understanding it is your wish to waive your right to a preliminary examination within that 21-day period. You won't be waiving your right to a prelim in general, just to have it within the 21 days so as you can confirm and work out this representation issue. Okay, sir? Okay. Is it your wish today to waive your right to a prelim within 21 days?
Yes, Your Honor.
And the people also waive their right to a prelim within 21 days?
We do, Your Honor.
All right. I find that the waiver of the prelim within the 21-day period to be knowing, voluntarily, and accurately made. And we will reschedule. What's the time frame here?
I would say 2 weeks or anytime,
weeks.
whatever after that, the court is ready.
All right. So we'll reschedule prelim for 2 to 3 weeks out.
Can we find something about 317?
Sorry?
Can we go 317?
Sure.
(8:30) June 13th.
June 13th at 8:30. And this was set for prelim on that date. That's correct?
Yes, I believe
Okay.
so.
All right. So yeah, we'll see who represents you in that time. You'll be responsible for being here June 13th at 8:30. All right, sir?
Yes, Your Honor.
Anything else for the record in 24013337, Ms. Wilson?
Not to the people.
Mr. Palmer?
Nothing further, Your Honor.
All right, Mr. Johnson, you're all set. Thank you for your appearance today.
All right. Thank you.
All right, so we're on the record in dockets 23-00387 and 23-03530. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Lavoy.
And sir, you are Christopher Lavoy, is that correct?
Yes, I am.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The people are ready to proceed. Mr. Lavoy does have two files before the court here today. We are ready to, I believe, finish the exam on the unlawful driving away file. The receiving and concealing, we are prepared to begin the exam today, but we will be requesting continuance.
All right, so that would be file. So we're ready to continue the exam on 23-03530. Is that correct? That would be the unlawful driving away.
Yeah, that one I am ready to, I believe, start and finish.
All right. Have we started? I don't think we've started that exam, right?
That's not, I don't believe so, no.
Okay. All right. And Ms. Robinson, that's your understanding. We're going to go on 23-03530, and then we'll address 23-00387 after we start that file.
It is.
All right. So are there any preliminary matters to come to the court's attention before we get started? Ms. Wilson.
Just as a general sequestration, I do have 4 witnesses here. They are in the jury room currently.
All right. And so I'll have counsel. If you see anybody who shouldn't be here as part of the sequestration order, you know the case better than I do. You just let the court know and we'll invoke the sequestration order. I don't think there's anybody in the courtroom right now who falls under that order. With that understanding, Ms. Wilson, you ready to proceed?
Thank you, Your Honor. Yes, the people would call Monica sober.
Excuse me, sir. Do I get to say anything?
You speak through your lawyer, sir.
My lawyer hasn't seen me or spoke to me at all about this case.
Well, then, so you speak through your lawyer. If you want a new lawyer, I don't think it's up to the public defender at this
I want a
time.
new lawyer.
All right. Well, you have this current lawyer you have with the public defender's office.
I'm not ready to proceed with this because I haven't been a chance offered to call any witnesses or present any evidence.
Well, you may not be proceeding today. Only the people are proceeding.
Okay.
Right.
Are we going?
But right now, it's my understanding, Mr. Lavoy can make whatever decision he wants to make. I think he's made the record that, but it's my understanding that the public defender gives one counsel per case. You don't get to pick and choose your lawyer based on your dissatisfaction with their performance.
I guess my question is more for Ms. Robinson, if she wants a moment to speak with Mr. Lavoy before we begin to address some of that, or if we're just ready to proceed.
Ms. Robinson.
I'm ready to proceed. If Mr. Lavoy still has additional questions, I'm happy to answer them.
All right, Mr. Lavoy, did you want to meet with Ms. Robinson before we get started?
I did. I do. I have many questions. I mean, she came with offers, but she says probably my best guess guidelines might be this or that. I mean, I can't go forward with an answer like that. I need to have an informed.
Look, so let's give you a second to talk to Ms. Robinson to work out, and then we'll go. Ms. Robinson, you can meet with Mr. Lavoy here, and then we'll proceed. Just let us know when you're ready, okay? And then Mr. Robinson, you can answer any of Mr. Lavoy's questions, and then we'll get started on the first witness.
Sounds good, Your Honor. Thank you.
Judge, you can get the courtroom, Judge. So we'll go on Mr. Wright's case. We're on the record in docket 24-01384. That is People of the State of Michigan versus Justin Wright. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji from the Public Defender Office, so Mr. White who's at my side.
And sir, you are Justin Wright, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are you proceeding?
Thank you, Your Honor. One of my officers was not going to be available today. I spoke with Ms. Wanji and she has expressed a desire to run the exam with both officers present. So be requesting an adjournment.
All right. And that's both officers would be Trooper Morgan and Trooper Easterday Lutz.
Correct.
Okay. That is, so the people are requesting an adjournment. Ms. Wanji, response.
Your Honor, I don't have any issue with that. Actually, I told her that I would like to have that run at the same time.
So I find that that there's good cause to adjourn, grant the adjournment. We'll have Mr. Wright not waive any of the 21-day rule or anything. This is to get both officers here to testify, and it would suffice. It would be, well, it's preferable to cross-examine both witnesses at the same time. So I'm going to adjourn for good cause. Which means, Mr. Wright, you won't be waiving any rights today, okay? This is for good cause. Now, if we show up and we don't have the witnesses at that time, we're going to reevaluate, all right? But you won't be waiving any rights today. We'll adjourn for good cause for both officers to testify, and they'll both be subject to cross-examination. And we will set for 2 to 3 weeks. Is that what we're looking at?
June 7th. And 9.
All right, we'll reset for good cause purposes for June 7th at 9 a.m. Anything else for the record in 24-01384 from the people, Ms. Wilson?
Not from the people, thank you.
Ms. Wanchi.
Yes, Your Honor. Thank you, Your Honor. I would like to advise the terror. I think that there is no really protected person here. There is no victim for the society. And there was a terror that was put on my client. And I think that he was told by the magistrate that it was for a previous fin and ruling that he had one many years ago. But he has no history of not appearing in court. He was on Zoom last time on time. He's here in person. And I don't know what the objective or what the purpose of him being on tether is. Summertime, Your Honor, we have discussed that, and he's very cooperative with me. He has come to my office so we can discuss the evidence and the discovery. And so I don't expect him not to come to court when requested to do so. And so for all those reasons, and he has ties in the community, he has his family here to support him. And for those reasons, we will ask the court to remove the terror and place any other conditions that the court may want to do. But if the reason for the terror is just to secure his appearance in court, I think that is overkill based on the fact that there is no failure to appear.
Right. I see why the tether was ordered. Ms. Wilson, at pretrial services, And then I'll ask for your opinion on this. They were not able to verify an address for Mr. Wright. A verified release address could not be obtained for the defendant. They made several phone calls and were not able. So they added the criminal record and the offense charge. So is the address, are you confirming that it's the address on Butler Boulevard? Is that the last known address? Is that the correct address?
It's a typo. It's 608, not 6080. So that might have been the reason why they couldn't find it. That's always been my address.
All right. So it's 608
Yeah.
South Butler Boulevard.
Yes, Your Honor. Lansing, Michigan, 48915.
That might be the lack of confirmation. 608 South Butler Boulevard,
Yes.
Lansing. 48915.
Yes. Your Honor.
That appears to be a typo. That's a 6080. Ms. Wilson, would you like to be heard on bond? This was set for a PR bond, and then the GPS was placed on it. It is not a typical play. It's not a typical. So you may know more about the case than I do, Ms. Wilson.
I was actually going to say that you might know more about it than I do at this point. So I would leave it to the court's discretion.
All right. Unless there's something else, Ms. Wanji is right. This is a flea and elude and R&O. There would be, I mean, so I would address this in the following fashion. I would address that shouldn't be it shouldn't be an issue, but so I'm going to address this as there will be a no contact order for Trooper Easterday Lutz and for Trooper Go ahead.
I'm not sure that we can really do that. They are officers. If they
If they
respond to something.
they could respond, but
Right.
that would not be on
them.
him.
Okay,
That would
I
be,
guess, yeah.
yeah, that would be on them, but
Okay.
responding or making a stop or anything
Right,
along those
mhm.
lines. If in the alternative, because I plan on removing the GPS.
Okay, yeah.
So that just seems to seems to make common sense here. If you're good without, and generally we don't do a no contact order on R&Os. So because of that, because the officers are responding to scenes, but of course, Mr. Wright can reach out. So in this instance, let's go ahead and let's just remove modify the bond to remove the GPS for for notification purposes. So we'll remove the GPS with the updated address verification. And I think the previous address verification, Mr. Wright is right. I think that was because of a typo.
Yeah, and I have no problem calling pretrial services, like,
All right.
and giving them an update or like contacting them.
Yeah, if you contact them, let them know the 608 address.
So call them after this?
Yeah, just contact pretrial services. We'll contact the GPS and tell them that it's been removed. And so they usually go to the jail to have that removed, right? Yeah, you see, if you go to the Ingham County Jail, they'll remove the GPS and we'll tell the private agency that it's to be taken off.
So don't go to the agency, go to the jail.
Go to the jail, right?
JSG. If he can go to
JSG
JSG directly.
If you can go to JS, yeah, go to JSG, go to the private agency. I just don't know what their staffing looks like. Okay, but start there. But they should get an email from us saying that the bond's been modified and the GPS is to be removed. Okay. And then we'll update the address. So bond modified bond modified to remove GPS with updated address verification, and then make sure that pretrial services has the current correct address,
Yes,
because
sir.
I do think that was a typo. And then we will adjourn for good cause to June 7th at 9 a.m. Ms. Wanji, anything else for the record in 24-01384 from the defendant?
No, you're not, thank you.
All right. That's all for the record. I'll see you on June 7th at 9 a.m. All right, sir?
Yes, sir.
All right, thank you.
So there's no.
No, Peter. Sometimes we do those, but not usually.
I think usually when it's like a really bad RNO.
Yeah, we'll
we
sometimes
or
do it.
Threats to the
Right,
officer's family or
exactly.
something, right?
Otherwise, I think we're creating more problems by
Yes.
doing it.
I'd rather not have something out there where law enforcement can't
Right,
do their job.
I agree. We have Miss Poe and Miss Nesson. Did you
Mr.
want,
Poe,
Mr.
let me just
Mr. Poe?
double check the hallway and
All
make
right.
sure I don't have a witness.
All right. And then in the meantime, you can bring up Miss Nesson after that case.
All
Your last transport was to take Abby or I have to.
I'm sure I'll have plenty more when I come.
That's true.
It's
But
true.
you know, and.
It's not last
You
anything.
can make a lot more money.
And we still have the afternoon.
Yes.
Let's not discount anything.
That might be a dealer's choice. Who knows?
Who knows?
Every time the thing she may need to be PRT.
I'm gonna go ahead and send an email that I'm here. Because I know that's the beginning of the 3 day. I'm here till 4:30. Because I'm gonna be here till 4:30 regardless. So if one of the other judges wants to take off,
Okay.
I'll send out that email because A, we have that hearing, and B, I've got some other work to do. But that doesn't mean that everybody else has to stick with me.
And you're on call.
And I'm on call for all 3 days.
Traditionally, the judge on call is
Yeah.
one that gets stuck standing in light if the others want to go. Unless, of course, it's during Judge Parker.
right, so we're on the record in docket 24-01378. That is people of the state of Michigan versus Dominga Nesson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji from the Public Defender Office for Ms. Mason, who's by my side.
And ma'am, you are Dominga Nesson, is that correct?
That's correct, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I did have one officer subpoenaed to be here today. I checked the courthouse and I haven't been able to find him. I did email him to see whether or not he was going to be here today, and I haven't received a response. I don't really have an explanation for his absence here today, but I would be requesting an adjournment.
Ms. Wanji.
You know, my client has a right to have a preliminary exam within 21 days of the arraignment today set for the preliminary exam. If the people are not ready to proceed, we will request a dismissal without prejudice. I have explained to my client that the case may be reissued, and if the case is reissued, she will be arrested again and again, but she understands that, and we're still requesting a dismissal.
All right, thank you. And it's your intent, of course, Ms. Wilson, after speaking with the officer as to the violation of the subpoena, it's your intent to reissue, is that correct?
Ultimately, it's not my decision, but based on my conversations with some of the higher ups in our office, I suspect so.
All right. Well, the defendant is incarcerated with a 1,000 cash surety, so Ms. Wanji,
If I may also, Your Honor, as
You
to
may.
that point, she is also in custody. She was remanded for an allegation of cutting her tether on a misdemeanor file before Your Honor, that's set for contempt hearing on Tuesday. She also has a hold out of Eaton County and possibly one out of Isabella. There's some confusion as to that.
all right, so there's two holes on her.
If I may, Your Honor, the
Yes.
case in Eden County has been resolved.
Okay,
And Isabella County, I don't think that there is, it's still going on, but I think that I don't think that there is a hold on that.
all right. And we have a hearing set for
Tuesday.
Tuesday.
Yep.
All right. All right, so I'm gonna adjourn for good cause. So Ms. Nesson won't be waiving any rights today, and I'll adjourn for good cause to find out, at least one adjournment to find out why the officer is not here and not answering the subpoena. And we'll reset after the hearing set for Tuesday, but we're probably looking at, you have to get your subpoenas out. So we'll reset for 2 weeks.
June 7th at 2 o'clock.
June 7th at 2 o'clock. All right, so so Ms. Nesson's not waiving any rights in this matter. We've adjourned for good cause in order to get the witness here to see why the witness is not answering the subpoena. We've reset for June 7th at 2 o'clock. For the record, I know that one other case has been resolved with Miss Nesson. I think that's the Eaton County case. There's another hearing next week concerning a violation of bond. And so we'll go from there. This has been reset for June 7th at 2 o'clock for good cause. Anything else for the record? Docket 24-01378, Ms. Wilson.
For the people.
Ms. Wanji.
You know, since there is a request for adjournment and the court has granted the request for adjournment, is it possible for the bond to be notified and allotted time that is to?
Not until after the hearing on Tuesday. So we see that hearing on Tuesday. I have no assurance that there's an appearance when the tether was cut off and she was on bond to this court. I want to make sure we have her by Tuesday.
Okay, so is the court going to have this case reevaluated on Tuesday?
On Tuesday, she's going to have to answer to the bond violation. Yes.
Okay, so I will ask the other attorney to address the.
We'll review bond on Tuesday.
Okay,
Yeah.
thank you.
Thank you. That's all for the record. 24-01378. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Thank you, Your
you.
Honor. You have a blessed day.
You too.
think that's it for this morning.
I think that's it for this morning. We have Mr. Hunt at 1:30. We'll see you and Miss Sutter here at 1:30 for the third time on that case.
No, yeah. Sorry, what was that, Judge?
We'll see you and Miss Sutter here at 1:30 for the third time on